they've added a category of leave, and this is an unpaid leave, for reproductive loss. So similar to the bereavement leave law that passed and went into effect last year, this law will require, as of January 1st, 5 days of unpaid leave for employees who experience a reproductive loss. What is a reproductive loss? It's defined as a miscarriage, a stillbirth, a failed adoption, a failed surrogacy, or an unsuccessful assisted reproduction, meaning that somebody had an implant of embryos and the assisted reproduction failed. So if an employee or the employee's spouse experiences any of these, they are entitled to this 5 days of unpaid leave. So the eligibility on that, very similar to sick leave, is if the employee's been employed for 30 days. Once they pass that 30-day mark, they are entitled to this, and the employee would have become a parent had not the failed adoption or miscarriage or whatever it is occurred. So that's what I meant when I said it's available to the spouse as well, not just the female employee. So here's something that I wanted to highlight because I get these questions quite a bit, and that is, does this apply to religious nonprofit employers? So as you may be aware, the FEHA, Fair Employment and Housing Act, when it comes to its prohibitions on discrimination, does not apply to religious nonprofits. They are not defined as an employer. In this new section, which is in a different section of the government code from the FEHA, it defines an employer as anyone who employs 5 or more employees. It does not have the carve-out, and so there's an open question of, does the general carve-out that applies to discrimination in FEHA apply to something like this? Again, my answer right now would be the safer course of action is to assume it applies to religious nonprofits until we get some guidance on that. There's no guidance right now. My read is that the FEHA exclusion only applies to the discrimination portions of FEHA, meaning the portions that say you can't discriminate based on religion or based on sexual orientation, things of that nature. But it does not necessarily apply to leave rights such as reproductive loss leave. That's my read right now. We'll see whether we get any guidance on that down the road. So if you have 5 or more employees, safer course of action, somebody comes in and claims they need reproductive loss leave, I would say grant it to them. Now, a couple of other details about this new law. There are some restrictions on usage. Employees can take this intermittently. They don't have to take all 5 days at once, but the leave must be taken within 3 months of the loss. So within 90 days of experiencing the miscarriage or failed adoption, they have to take all the 5 days, otherwise they go away. And if you have multiple losses in a year, the maximum usage is 20 days. So employees can't take more than 20 days for reproductive loss leave in any 12-month period. Here's something that I think is going to create all sorts of issues. The law does not require employees to provide documentation of the loss. So unlike bereavement leave, where the employer can require proof of the death or the memorial service, the employee in the reproductive loss leave provisions doesn't have to provide any proof that they actually had a failed adoption or a miscarriage. So I'm sure there'll be a lot of questions about that, but as of right now, my guidance would be if someone wants to take reproductive loss leave, I would not require any documentation, and I would grant them the leave. So Lastly, this is an unpaid leave. However, employees can use paid leave that they have available, whether that's vacation, whether that's sick leave, whether that's PTO. However, the legislation says that employees may. It does not say that the employer can require use. So I don't believe that employers can say, hey, you're taking reproductive loss leave, I'm going to require you to take vacation in conjunction with that or sick leave. And you certainly could not require sick leave because employers cannot require employees to use their sick leave. It is completely up to the employee whether or not they use it.